Something changed in Washington last week. And if you are on an H-1B, if you are on OPT, or if your employer is even thinking about sponsoring you in 2026, you need to stop what you are doing and watch this entire video. Because the window to act is not closing. It has already started closing. And most people in your situation have no idea. Welcome back to Immigration Path USA, the channel that cuts through the noise, the rumors, and the panic, and gives you exactly what you need to know when you need to know it. I'm so glad you're here today because this one is serious, and it directly affects tens of thousands of people watching right now. Before we go any further, a quick but important note. I am not an attorney, and nothing in this video is legal advice. Everything you are about to hear is for educational and news purposes only, based on publicly available USCIS guidance, Federal Register notices, and policy updates. Your immigration situation is unique. Please always consult with a licensed, qualified immigration attorney before making any decisions about your case. Now, let's get into it. Here is what is happening. USCIS has finalized significant changes to the H-1B program, changes that affect the FY2027 lottery, which means the registration window opening in March 2026 is not operating under the same rules you heard about 2 years ago. It is not the same system your senior colleague used when they got selected. The rules have shifted, the fees have increased, and the selection process itself has been redesigned in a way that is going to surprise a lot of people, including some employers who may be about to make a very costly mistake. Let's start with the single biggest structural change. And this one matters whether you are a first-time registrant or someone who has been through this process before. USCIS has moved to what is formally called a beneficiary-centric selection model. Now, that phrase sounds bureaucratic, so let me explain exactly what it means for you. In the old system, if you were a highly sought-after candidate, maybe you were a software engineer fresh out of a top university, or a data scientist with 3 different companies interested in sponsoring you, each of those employers could submit a separate registration on your behalf. 3 employers, 3 registrations, 3 chances in the lottery. That system was gamed heavily. Staffing companies and visa mills were submitting dozens of registrations for the same individuals, flooding the lottery with duplicate entries and dramatically reducing the odds for everyone else playing by the rules. USCIS saw it, Congress heard about it, and now it is over. Under the new beneficiary-centric system, the lottery selection is tied directly to you, the individual, not to the number of employers registering on your behalf. Your passport is your anchor. 1 passport, 1 entry into the lottery. It does not matter if 5 companies file for you, you get 1 shot. If you are selected, all 5 petitions can still be filed, but your selection odds are no longer multiplied by the number of sponsors you have. The days of lottery stacking are gone, but here's the catch that most people are missing, and this is critical. While this change was designed to protect honest applicants from fraud, it has a painful side effect that nobody in your LinkedIn feed is talking about. International students on F1 OPT or STEM OPT who had been quietly relying on multiple employer registrations as a kind of informal insurance policy, submitting through their primary employer and a staffing company simultaneously, that strategy is now completely neutralized. If you were counting on that, you need to recalibrate your entire approach before March 2026, and that is not the only pressure hitting this cycle. Let's talk about fees. Because the numbers have changed significantly, and they are already making employers hesitate in ways that could affect your sponsorship before a single form is even filed. USCIS implemented a sweeping fee increase that took effect in 2024, with full impact now being felt across FY2027 filings. For employers filing an H-1B petition, that is the I-129 form, the base filing fee has increased substantially. When you layer in the asylum program fee, which most employers must now pay, the fraud prevention and detection fee, and then premium processing, if the employer wants a decision within 15 business days, you are looking at a total outlay that can reach anywhere from $4,000 to over $5,000 per petition, before attorney fees, which commonly add another $2,000 to $4,000 on top. For a large tech company sponsoring hundreds of workers, that math is uncomfortable but manageable. For a mid-sized startup, a small consulting firm, or a regional healthcare provider sponsoring their first or second H-1B worker, that total cost is now a serious boardroom conversation, and some employers are quietly pulling back, not because they do not want to sponsor you, but because the cost-benefit calculation has shifted. This is where it gets critical for anyone waiting on a sponsorship offer, especially international students approaching the end of their OPT period. Let me tell you about a situation that is playing out right now across the country. And while the name is fictional, the circumstances are absolutely real. Meet Priya. She is a 26-year-old data analyst who graduated from a university in Texas with a master's degree in computer science. She is currently on her first year of OPT, which gives her until mid-2026 before she would need to transition to STEM OPT or get selected in the H-1B lottery. Her employer, a mid-size fintech startup with about 80 employees, has been telling her informally since she was hired that they would sponsor her. Her manager loves her work. Her performance reviews are excellent. But last month, something changed. The startup's finance team ran the numbers on the H-1B filing costs for FY2027, factored in the fee increases and attorney costs, and presented the total to the CEO. The CEO did not say no, but he said wait. And now Priya is in a holding pattern with a clock ticking, no written commitment, and a registration deadline approaching in March 2026 that her employer may or may not meet. Priya's situation is not unique. It is happening in offices across America right now, and the tragedy is that many workers in her position do not realize they have options beyond waiting and options beyond panic. Which brings us to what you should actually be doing right now, because understanding the problem is only half the conversation. Let's talk about the 3 concrete steps you need to take before that March 2026 registration window opens. Step 1. Get your documentation in order immediately and do not wait for your employer to prompt you. That means your current valid passport, your academic transcripts and degree certificates, your I-94 arrival and departure record, all previous visa stamps and approval notices, and if you are on OPT or STEM OPT, your EAD card and your I-20. Have all of this organized, scanned, and stored in a secure digital folder. If there is any discrepancy, a name spelling difference between your passport and your diploma, an expired document, a missing I-20 endorsement, you want to know about it now, not in April when a petition is already filed. Step 2, have a direct, documented conversation with your employer. And I want to be specific about the word documented. Do not rely on verbal reassurances. Send a follow-up email after any verbal conversation confirming what was discussed. Ask HR or your manager directly. Will the company be registering me for the FY2027 H-1B lottery in March 2026? What is the timeline for that decision? Who is the attorney or firm handling the filing? You are not being difficult. You are being responsible about your own legal status, which is entirely appropriate. A good employer will respect that conversation, and their response, or their delay in responding, will tell you everything you need to know about where you stand. Step 3, identify a backup. I know that is not what anyone wants to hear, but immigration planning in 2026 requires contingency thinking. If you are on STEM OPT, you may have more runway than you realize. Up to 24 additional months beyond your initial 12-month OPT period, giving some individuals until late 2027 or even 2028 before their status expires. That time, if you have it, is valuable. Use it to consult with an immigration attorney independently, not just the one your company hired, so you understand your personal options. CAP-exempt employers, O-1 visa eligibility, L-1 pathways if you have multinational experience, or even exploring whether graduate school re-enrollment makes strategic sense. These are all conversations worth having now while you still have time to act rather than react. Now, before we talk about what comes next legislatively, a word about scams, because this environment is a breeding ground for fraud. Anytime there is policy uncertainty and emotional vulnerability around immigration, predatory actors emerge. Be extremely cautious of any individual or service that promises to increase your lottery odds, guarantees H-1B selection, offers to file your registration without an employer sponsor, or asks for large upfront payments with no verifiable credentials. USCIS does not call you by phone. USCIS does not email you demanding immediate payment, and no legitimate service can manipulate the lottery outcome. If someone is claiming otherwise, you are looking at a scam, and potentially a federal crime if you participate in it. So where does this go from here? Because this story is not finished, and understanding the trajectory matters. USCIS has signaled continued scrutiny of the H-1B program under the current administration. There is ongoing litigation in federal courts around aspects of the registration rule, and advocacy groups on multiple sides, from employer coalitions to immigration reform organizations, are actively engaged. Congress has not passed comprehensive immigration reform, and the likelihood of major legislative movement before the end of 2026 is low, but not impossible, particularly if there is continued pressure around workforce shortages in healthcare and technology. What this means practically is that the FY2027 cycle you are navigating right now is operating under rules that could still face legal challenge, administrative revision, or enforcement interpretation shifts before petitions are even adjudicated. This is not a reason to panic. It is a reason to stay informed, stay connected to credible sources, and work with professionals who are tracking this in real time. The international students and skilled workers going through this process are not statistics. They are engineers, building software used by millions of people. They are nurses and doctors working in communities that would collapse without them. They are researchers, educators, and entrepreneurs who came here, followed the rules, invested in education, paid taxes, and are now navigating a system that is asking more of them every single year. That story deserves clarity. It deserves honesty, and it deserves people who will tell you the truth even when the truth is complicated. That is what we do here. If you want accurate, fast, and reliable immigration updates, subscribe to Immigration Path USA right now and turn on notifications. Immigration policy is changing rapidly, and staying informed is no longer optional. It's essential.